started, Anita. So welcome everyone to our presentation. Today we're going to be talking about the Beneficiary Blueprint from planning to inheritance. And we're happy to have you join us today. Anita, why don't you go ahead and get us started?
That's great. So for those of you who don't know me, my name is Anita Shteynberg. I'm one of the partners here at Jensen Estate Law. We are here in Seattle, Washington. Our main office is in the Northgate area. And I have a little disclaimer for all of you either attending today or watching the recording. First of all, you should know that this video or this webinar is being recorded and will be available later. The content provided in this webinar is for informational purposes only and is not intended as legal advice. We are providing information today that may not be applicable specifically to your circumstances, so we strongly recommend consulting an attorney and obtaining that legal advice for your specific individual situation. If you do have specific legal questions and want personalized advice, we are still taking on new clients, and we'd be happy to see our returning clients as well. So feel free to call in and schedule a consultation. So a few of the key concepts here that we are looking to speak about this afternoon. I'll be taking on a couple of these sections here, the statutory beneficiaries, what might be the default rules under Washington state law and what might be the requirements under Washington state law. Talk a little bit about the beneficiary selection process. And what was your plan, Derek?
Right. Well, this is a topic, beneficiaries are a topic that are near and dear to my heart, both as a beneficiary of an estate and also as someone who's planned an estate. So this is I just am really going to be looking at some of the nuances that we sometimes will see and think about when we're picking our beneficiaries, the ways we can maybe distribute to them, how we might make different decisions on that, the interactions the beneficiaries might have with the planning, who's doing the planning, and then also how the other beneficiaries, their trustees, the other fiduciaries, and really trying to understand the expectations that everybody would have within that.
So the first slide here is deciphering beneficiary types. There could be different types of beneficiaries. You may already be a beneficiary of perhaps an inter vivos trust that someone set up on your behalf. Perhaps you became a beneficiary upon the death of a parent or grandparent, but perhaps you are still in the process of deciding who your beneficiaries are and possibly revising those selections over time. So we have estate beneficiaries. Estate beneficiaries are typically people who inherit assets according to the terms of someone's last will and testament. The assets are distributed through the court probate process. Trust beneficiaries are people who take the benefit of trust assets. Now, those people might not be the ones managing the trust assets. The manager of the assets is the trustee, and it may be a different person or different entity than the beneficiaries themselves. This structure is often very helpful when beneficiaries are too young to manage assets themselves, or maybe they're incapable of handling the responsibilities, or maybe the grantor, the person who set up the trust, wanted to add asset protection for the beneficiary. And we also have non-probate beneficiaries. Those are assets that individuals receive after the death of someone who owned perhaps an account that had a beneficiary designated on it. For example, a life insurance policy. If you are named as the beneficiary of that policy, you would inherit the proceeds of that policy as a non-probate beneficiary. I often find that those, Taylor's helping out with the slides today, and if I could ask Taylor to go back to the previous slide, I just had a couple additional comments about non-probate beneficiaries. So I often find that this is one of the most problematic areas of somebody's estate plan. They may have non-probate beneficiaries directly on their financial accounts that does not align with their estate plan. So it could be that they have some sort of, or you may have some sort of unequal division of assets directly on an account or a life insurance policy. That's fine if that was your intent, but if you have just one of your 3 children named as the beneficiary of a life insurance policy, this could create unequal distributions. So just to think through those and make sure your beneficiary designations are aligned with your wishes. And somebody could be a beneficiary in any of these 3 ways or a combination of them. So I think we're ready. Taylor showed us a preview of the Simpson family tree. I wanted to use this as an example of how assets might be distributed if somebody dies without a will. So if you die without a will, most states or all states in the US, there's a default estate plan in place. So the state legislature has enacted intestate succession laws, and there's already an estate plan for you. And may not be the estate plan you want, but it would be executed if you do not have a will, trust, or estate plan of your own in place. So let's say, for example, Marge Simpson dies without a will. Well, Homer is her husband. If Homer is Marge's husband, and if Homer is surviving, he would inherit all the community property. So the family home, the car, the joint bank accounts, all of that would go directly to Homer if he's surviving. But any separate property that Marge has maintained on her own, so if she had a prenuptial agreement and she called out premarital property as her own separate property, or if Marge had inherited property from her mother, Jackie, that may be separate property. Separate property is treated a bit differently under intestate succession rules. Half of that would go to Homer, and half of the separate property would go to her 3 kids. Keep in mind, if the kids are still minors, the inheritance for the children would have to go through the court conservatorship process. So one more example under intestate succession, if Patty, Marge's sister, were to die without a will, she does not have children and she is not married. So her intestate heirs would be her surviving parents under Washington state law. If she doesn't have parents surviving, then her heirs would be the descendants of her parents. So her sisters, Marge and Selma. And so Washington guesses what you would want. It's basically your closest relative. The spouse has lots of rights. If we have to branch out further along the family tree, it might go up to grandparents and descendants of grandparents. There are also family protection statutes. So if you created a will before the birth of a child or legal adoption of a child, or if you created a will before you got married, then the law assumes that that if you died without having changed your will or without having signed a new will, the law assumes that you probably just forgot to change your will, and they will insert additional provisions in the will that you may or may not have wanted. We have the omitted child statute and the omitted spouse statute. So in those scenarios, those children or the spouse would take their intestate share, regardless of what your will said back when you wrote it. Family support statutes. So you may think that you could write a will and decide where your assets go. For the most part, that's true. Or you could have a trust that contains those instructions. But we do have, under Washington state law, certain family support statutes that allow a surviving spouse or if there is no surviving spouse, minor children, to petition the court for a basic award. So it's not very easy to disinherit a spouse or minor children, because those people would still have a right under Washington state law to claim a basic award. The basic award is the greater of $125,000 or the median sale price of a single family home in the preceding calendar year as determined by Washington Center for Real Estate Research. That's under the University of Washington. They publish the amounts each year, which are the median home prices. And with current home prices, I don't think you can find a county in Washington state where the price is less than $125,000. So it's going to be quite a sizable amount. In King County, I think San Juan County is the highest in that median home price. So keep in mind, a spouse can always petition for this minimum amount. And if there is separate children, if there are any separate children as well, the surviving spouse may need to share that basic award with the separate children as well. And then a few more Washington state statutory rules that might override your will. That's in the case of divorce. So if you get divorced after you sign your will, Washington state law assumes that you want to disinherit your ex. And the will be read by the courts as if your ex predeceased you. So it may not be what you want. Maybe it is. Maybe it's like your ex is dead to you and you didn't want to give him or her anything. But I often find that clients do want to leave something for their ex-spouse. It may be that they have joint children together and the co-parent is still raising the children. So you want to make sure that the co-parent has enough for themselves and for their children to raise them. Also, I've heard that another concern is that you don't want the ex-spouse to be a burden on children. So you want to leave them something as well. So this is something that you should consider and make sure you review your estate plan upon any major life change such as divorce. So we talked about the default rules under Washington state law and some of the other laws that could override your own testamentary intent. But you, for the most part, do have the freedom to decide who your beneficiaries are. Your selection of beneficiaries is a vital part of managing your legacy. And not only do you want to ensure that your assets are distributed according to your wishes, but you may be thinking about providing financial security for your loved ones and also providing a way to continue on with your values that that you hold important to you, so that your loved ones can take the benefit of that even when you're gone. So we have some ways that you can make specific gifts, general gifts, and residuary gifts as well, which is the next slide here. Specific gifts. So once you determine who your beneficiaries are, you can also decide what assets each person or any entities might inherit. Entities may mean charities. The specific gifts are possible if you have a specific real estate, which you want a particular individual to inherit. You may do that. But keep in mind, real estate comes with costs, and you have to pay the taxes and the insurance. And so make sure that the person is going to have enough liquid assets to take over a mortgage or has enough income to do that and to maintain the house as it should be. But if Maggie is living in the house and it's always been in her house and it's just titled to you, You may leave Maggie her house in your trust or will, or maybe you give it to her during lifetime as a lifetime gift. I don't like to leave certain financial accounts to certain individuals. There's nothing under the law that prohibits it, but financial accounts are always changing. Valuation changes, the account numbers change, banks take each other over, you close accounts, open accounts. So specific gifts of financial accounts are disfavored in my practice. But you could do a general gift if you have certain amounts that you want going to certain people. So say you want $100,000 to each of your nieces and nephews. We can make that kind of instruction as part of your estate plan. And maybe your main beneficiary is your daughter. So she would be your residuary beneficiary. Keep in mind, all those specific gifts and general gifts are paid out first. So if you have 10 nieces and nephews and each one gets $100,000, and then Maggie's house went to Maggie, there might not be anything left over for your daughter when we get down to those residual gift instructions. So keep in mind the order that those gifts are paid out. There could be abatement of those assets if there aren't sufficient assets to pay for all the gifts you've provided for. And the final item of gifts I'll call out is tangible personal property. Those include anything in your home, your tangible furnishings, furniture, boats, automobiles, even airplanes, jewelry, family heirlooms, as well as precious metal that's not currency. So any collectible coins or all those gold bars you have saved up, those could have significant value. And if you would like to select the people who should inherit those assets, you may use a personal property memorandum. The memorandum should be referenced in either your will or trust, but that's a very convenient way for you to decide where those tangible items or how they should be inherited and by whom. And that's a document that you can fill out on your own and sign it. There's no formal notary or witnessing required. The document should be dated. But this is a good opportunity to have a conversation with your beneficiaries about which items they might like to inherit. It could be that you gave your entire baseball card collection to your neighbor, but maybe your neighbor doesn't see the value in those cards and would not appreciate that. So there could be somebody else who might value those items more. So this is a conversation you can have with your beneficiaries. I've seen clients, they have a big spreadsheet of items that they create of their own tangible personal property, and they allow their family members to choose which items they would like to take. It could be a rotation system or a lottery where you take turns deciding which item you would like. If there are 3 people, it would go in order, and each person could select an item when it's their turn. So that could be a nice way to start a conversation about those tangible personal property items. If you haven't left instructions for those items, it could be a point of contention for your survivors after death if if your son and daughter want to fight over your gold coin collection. So good way to sort through those issues is by bringing it up now and making sure it's all provided for and clear.
So assuming that we're going to be distributing cash or other assets to individuals, we end up saying, well, how are those distributions going to be structured? The most common way the distribution is going to be structured is just an outright distribution. So this could be in the form of a check being delivered to the beneficiary, or money being wired or sent into their account, or as Anita was just speaking of, an outright distribution of a piece of tangible personal property is just going to be a distribution, handing that property right on over to the beneficiary who's receiving it. If it's financial accounts, this might be perfectly suited for someone who is financially mature, understands how to manage those assets, but it really wouldn't work for someone who has some kind of incapacity, who's underage, who is maybe not even mature enough or ready to take on the responsibilities of managing the types of assets that we're distributing. So it is often something that we're going to look to see. I'll have clients tell me, well, can we stipulate that this needs to happen, or this should happen? And when we think about stipulation, what we're really talking about is the fact that outright distributions don't have control and they don't have asset protection. So that tends to lead us right into the realm of some type of a trust then for that beneficiary. And there's a number of different ways we could structure these trusts. I'm going to run through a few of the basics here, and then I have a few more provisions. Understand that some of these can be added together and go from one to the other, or have multiple features in it. So if we're speaking of, for example, an income trust, that does not necessarily mean that principal cannot also be distributed under the provisions of the trust. So first of all, with an income trust, what we're really doing is we're going to have a trustee who's set up there to manage those assets and distribute the income. Generally, an income trust will say all the income that's earned by the trust. This is very simple, easy as far as taxation, because it's going to be considered a simple trust for tax purposes. And when they're reporting the income then from this trust on the 1041, that they will show the income being distributed out to the beneficiary. There's some asset protection with this type of a trust as to the principal. If the beneficiary doesn't have a right to receive or demand the principal to themselves, then that principal would be protected. So those are the benefits of an income trust. It does provide some management of those assets, and it can provide some protection for the principal as it goes along. Often we will want to have something a little bit more controlled than just a simple distribution, and that's where we might be looking to a discretionary distribution trust. And here we'll see that the trustee has the ability to really make decisions on the distributions to the beneficiaries based off of their discretion, what they believe is in the best interests of the beneficiary, and all of the beneficiaries. Actually, the trustee is charged not with just looking out for the best interests of the beneficiary of that trust, but also the remainder beneficiaries of that trust share. This also is the version that would provide the best asset protection that's available. If you had a purely discretionary trust with no mandatory distributions, and you had a third-party trustee who is not under the control of the beneficiary, that provides the most asset protection that we can have in any kind of a trust situation. Typically, we'll think of that those trusts should end at some point, however, and this is something that we will see. I'm sure Anita has seen it also when you're reviewing existing documents of clients. That we'll see a typical 25, 30, or 35 age distribution period. These are really aligned or set to align with different stages that the beneficiaries might be going through. So, for example, maybe they're completing college, buying their first home, getting married, having a child. These are kind of the typical traditional stages we can think of, but maybe those don't apply as well right now. And so maybe we would want to adjust those ages. Maybe those ages should be a little bit longer. And it can also be, this one is often combined with an income or discretionary trust to provide an opportunity then for the trustee or for the beneficiary to take the distributions out of the trust entirely. Okay. Once we get past those basic building blocks of a trust, now we can start to think about some of the other types of provisions we could have in those trusts for the beneficiaries. So one version we might think of is something that is more of an incentive trust, and this would be there to really incentivize the beneficiary to achieve certain goals or to model certain behavior. So for example, you could have it that education is important, or that employment, being employed, staying employed, or could be important, contributing to retirement or qualified retirement plans. These types of incentives might be built into an incentive trust. Going beyond just these general kind of goal and behavior types of incentives, we might think of trying to disincentive somebody. And so you could have an incentive trust that does the opposite. It says, well, you're not going to receive distributions if, in fact, you are, for example, drinking or using drugs, for example. We tend to not prefer the disincentive trust. We prefer to have it be an incentive trust, work on the positives, but they are obviously a mirror image of each other, and sometimes one might be more important than the other. A new concept that is kind of building strength out there is this idea of a well-being trust. It's not going to be as defined certain goals and behaviors, but it's really more looking at the overall health, well-being, happiness of the beneficiary, trying to find ways to contribute to those activities and lifestyle that will enhance their life as they go on. This is can be kind of fun to think about, providing these opportunities. And maybe it is something that we would really we can see in today's modern world might be something they can't do themselves, but if they had a trust that could provide that kind of extra, a bit of extra for them to do that, that might be the goal that we're trying to achieve. A unit trust is a little bit of a newer version of the income trust. Really, it's a way to take away some of that natural tug and pull that could be existing between the beneficiary and the trustee. When you're investing purely for income, as the beneficiary might like, that would generally mean you're not going to be investing for long-term growth, which is what the trustee may believe is the best interest. So here with the unit trust, the investment and the return of the trust is in the best interest of both the trustee and the beneficiary to get the total return, and that's the type of investment it encourages. It also helps to deal with downturns in the market or provide more benefit for the beneficiary if there is growth in the market. So for example, you might have a 4% unit trust. The trustee will know that at the beginning of the year how much they're going to be distributing throughout that year, and the beneficiary will know how much they can expect to see from the distribution of the trust. And that helps them to budget and really encourage a type of working together relationship that we would like to see from those beneficiaries and trustees. Now, sometimes we will have a beneficiary who has a health issue, and we're going to need to be maybe having a special purpose relating to this. So it might be that the beneficiary will never be able to manage the assets themselves, or that if we gave them those assets could cause them to lose government benefits that they're receiving, or would be at risk from medical claims and the like. So here we might be looking at some special provisions we would use to deal with that. A special needs trust is a well-known opportunity for this. It is specifically designed to limit the types of exposures that can be distributed from the trust to only those things that will not be paid by government benefits. So for anybody who is a needs-based, receiving needs-based government benefits, a special needs trust would be an ideal option to consider whether it makes sense for them or not. However, what we find with the special needs trust is that the language, the distributions are very restrictive. If someone is in fact needing significant needs-based government benefits, the restrictions inside the special needs trust may amount to really only a small amount per year of what the trust corpus or balance might be. So that may not really align with what the overall objective of the grantor or the benefactor is. And maybe, in fact, we would prefer to look to more of a discretionary support trust. With a discretionary support trust, it's a discretionary trust like we had spoken of on the last slide, where the trustee will maintain control and act of all of the assets and will be charged with really looking out for the best interest of the beneficiary. But here, the specific intent is to really look at ways to make sure that their medical needs and other needs are being met, and including any kind of services or housing or other types of services that might otherwise be covered by government benefits if they were able to be eligible. So with this type of a trust, we are really going to be taking on the burden of those benefits and disregarding or not trying to plan to get the government benefits. Now, some people will say, well, maybe we can have some kind of informal way to do this, where possibly other family members will be responsible for the burden and the care of the beneficiary. And in those circumstances, the idea might be to make larger distributions to those beneficiaries, those family members who are taking on that role. This can work. However, there can't be any written, requirement or really implied requirement that be done. This has to be, specifically directed to them. Essentially, you'd be disinheriting then the beneficiary with the family need, the disabilities, in order for them to qualify for government benefits. Those assets are then, however, at risk in the hands of the beneficiary, the family member beneficiary who received them, and potentially then would not go back to provide benefits to your family member with disabilities. Right. So I did mention disinheritance. In some ways, that's a troubling word for us, and we're not something that most of my clients who consider disinheritance will go too lightly. One of the reasons might be there's an estrangement. There might be maybe some type of financial or other estrangement that happened during, more recently, and so they've been estranged, or it could be that really they've never been close to this family member, and they've decided that it's in best interest to go ahead and disinherit them. We like to think first and ask the question, however, is there an alternative to that disinheritance? So, for example, sometimes the concern might be that if a specific type of asset was given to that person, that they would misuse it or abuse it, or if it's something that's a family heirloom, for example, it might be lost. And so then that's the question where maybe a trust could help with that. When we think also with those beneficiaries, possibly there's ways that we can, put language in the document explaining why, in fact, they're receiving a smaller portion or not receiving anything from there at all. But often we are thinking, when we're thinking about the alternatives, we are thinking about different types of trusts, asset protection issues, and the like. So there can be all kinds of, depending on the circumstances, there might be many alternatives to this. One might be, for example, that the concern is that we'll have a lawsuit that's coming along, and that maybe it's from some kind of activity that the beneficiary is involved in, and we want to protect the asset from that. So could we use an asset protection trust then to help protect that asset? Our other types of beneficiaries we're often looking at is charitable beneficiaries. And so when we're thinking in terms of the documents, what's the best way to make those charitable gifts? I've given a couple of examples here. With the types of gift that we could make, Anita ran through these also, but a specific gift is often used for charitable gifts. You can do a $10,000 gift, for example, to your college or university. That would be a specific gift. It's a known dollar amount. It's set. A specific gift does take precedence over other gifts. So those gifts, the benefit there is that would happen sooner rather than later during the administration process. And so the charity would receive their gifts more, maybe before the other residuary beneficiaries. A residuary bequest, that's going to be a percentage, so 10% to your church, for example. Is there an example of a residuary gift? Those beneficiaries, those charities, then would be hanging on, waiting till the final distributions, and so they would continue to be beneficiaries. The third way that we think about really within the documents would be a contingent distribution. And for example, if all of us are gone, our remote contingent distribution provision might say, well, it should go to, I don't know, United Way or American Cancer Society, for example. Sometimes clients will have a desire to have more control and make changes to their beneficiaries. And for example, they might wish to, their charitable beneficiaries, they might want to change it every couple of years. They might want to vary the types of beneficiary, how they're benefiting those charities. And this is something that I would encourage you to consider the donor advised funds. Many of the financial institutions now have these set up. Seattle Foundation has the donor advised funds also. So essentially a community foundation that's been created either by a charitable organization here locally or the fiduciary company like Fidelity and Schwab, and you can have charitable accounts under that. Those charitable accounts are really donor advised funds, and you can direct gifts from your estate planning documents to those donor advised funds. Within the donor advised fund, then using the structure that the organization has, you can easily make your adjustments and your designations on where those funds would go at your death. We tend to like this approach if you're going to name, if you want to name a charitable bequest for, say, a traditional IRA. Traditional IRAs are great to make charitable gifts with. They don't have a tax cost as it goes off to the charitable beneficiary. And so the charity would end up getting the full use of those funds. And with regards to doing that, however, that can be a little tricky within your documents. But if you did direct that retirement account or a percentage of that retirement account to your donor advised fund, then those funds would be directed over by the charitable organization there, the community foundation, and they would take care of the distribution from there. So it can be very efficient for your fiduciaries, for your personal representatives and your trustees as they're administering the estate. For charitable trusts, this is really a more advanced planning tool. You can make gifts into a charitable trust during your life or at death. The charitable trust can provide different types of trusts. It could be a trust that is creating a split interest trust. So, for example, you may retain a right to some income from that property during the remainder of your life, and then the trust or the property in the trust would go on to the charities at that point. Or there's a version that's kind of the reverse of that, where you can create a trust and have a stream of income on an annual basis going to a charity, and then you can direct where it goes at the end of the term. And so that's a charitable lead trust. It's a little bit more unique. We don't see those as often, but charitable trusts are great tools also. So one of the other considerations that we often will see is, how do we do the division? Should it be just equal? Is equal always best? Is what we're saying here. So imagine you have 3 children and you'd like to leave a share to each of them. Should it be 1/3, 1/3, 1/3? Or is there a more equitable way to do that? If we went and looked at each of the children's circumstances, we might find that there's a significant differences in where they're at. For example, one of the 3 might have 3 kids, while another one has no children. One may be a high earner, potentially a doctor, for example, and the other might be a lower earner. And then one may have healthcare needs. We talked about that earlier. So these are considerations that might play into the idea of maybe changing that and not having it be a third, a third, a third in the situation that I was mentioning. Not saying I'm sure which would be the correct there, but that would be something you can have a different distribution, not just a third, a third, a third. And we see that quite a bit when we're thinking about the individual circumstances of each beneficiary. And additionally, there might be a situation where it's a unique asset. So you could have, and I didn't have this one on here, but this would have been a good one also. For example, if there's a beneficiary who works in a business versus beneficiaries who are not working in the business, etc.
I'd like to jump in with a question on that, Derek. I see that we don't have too many questions in the Q&A, but I have a question for you. How do you deal with family situations where a parent has paid a significant cost for one of the children? Maybe the parent paid for grad school, but the other children did not get the benefit of that type of payment. Maybe the other kids didn't go to grad school or they got scholarships. How do you deal with those types of situations? Would there be an unequal distribution based on that, or could it be considered instead an advancement?
Oh, it's a very good question. Yeah, it is interesting, and it, often that'll go back to the arrangements and that were made with the kids, the expectations that were presented with the children as they were growing up. But yes, it often is the case that the clients will want to equalize that distribution in some manner. So one approach would be to go ahead and draft in a specific bequest, equal to a certain amount. So for example, if you could show that the value of that was $100,000, you might add a specific gift to the other children of $100,000 that would kind of come off the top before they were doing the division. Now that doesn't take into consideration the fact that the $100,000 20 years ago is not worth what $100,000 today is. So there might be that kind of distinction on that. But another approach, which, as you're saying, is to think of it as that we're bringing it back in to the estate and treating it more like an advancement. So, if that's the case, we could draft language in like that. I think the end of the result of it is the same if it's either a specific bequest or treated as an advancement. However, typically what I will do is that'll open up a conversation about gifting, and whether or not it might be appropriate to do some equalizing gifts now instead of waiting. And so that's another way to look at it. Sometimes we will see that that was treated as a loan, not a gift, the payment for the extra school, the graduate school, for example. And so we would look into, inquire about that, find out if that was a documented loan, and how the client would like to treat that. Should we treat that loan as if it is forgiven, or should we consider it as a share that shall be distributed to that beneficiary, essentially reducing their or increasing the amount that they're going to the other beneficiary. So there's a number of ways, depending on how it was really put together by the family and dealt with in the family. But that also brings me right into my next topic, which is how about bringing the beneficiaries into the conversation, bringing them into that. Communication is one of the keys, I think, to really having a successful estate plan. So for example, bringing a beneficiary in can really help us to have a more tailored distribution that meets their specific needs. And that'll end up giving us a higher confidence in success of the planning and more effective planning. So for example, if we're thinking about those beneficiaries, if we understand that one, they may all look the same right now, but if we understand that one has a health issue that they're going to be facing later in life, or, for example, maybe they will have multiple kids, and we're thinking about how we're going to get all those kids through college. These are things that might impact the way that we're looking at those distributions, as is, the question of maybe divorces or business interests, if they're potentially going to have, be an asset protection issue or managing of those assets. One of the other benefits of incorporating the beneficiaries into the planning process is they can start to learn about what is going on with the estate plan. So they're less likely to be surprised. So for example, if there was a variance that was made in there and one beneficiary was receiving a larger share than the others, if all the beneficiaries knew that was happening and were expecting it, then that's not a shock that would happen at the time of death. And if there are any concerns from the beneficiaries, those can maybe be addressed or explained ahead of time. There's also an opportunity here for the beneficiaries to learn about estate planning, to understand how property transfers, the kinds of issues we might have with taxes and asset protection, management of estates, and so it can be very helpful for those beneficiaries. Now, if it is going to be a situation where we're going to have a trust that's going to be continuing, then another beneficiary might have is having the beneficiary have some type of a say in who that trustee might be for them. This could be that they're going to have a say right during the planning process. We're going to put those names in, or it might be that we're going to grant the beneficiary some authority to decide who the trustee could be, or when a trustee might be removed and replaced, for example. But having a beneficiary be someone who can work with the trustee and having the trustee be possibly selected by the beneficiary can help to encourage a good relationship there, which again is going to help with the success of the overall plan. Okay. So I'm going to shift gears a little bit, and this is a little bit on to the estate administration here, Anita. So this is an interesting one. What happens so you are the beneficiary of an estate? What is from that perspective now? So no longer from the planning client, but from the perspective of the beneficiary. And where we see this most often is during administrations, estate administrations. So if someone has died, but it could also be during incapacity. But let's say that, for example, you know that you're going to be inheriting. What steps could you take? What's the right approach here? So first of all, have meaningful conversations early. So imagine having that conversation with your parents, your grandparents, or the person who you know is going to be leaving assets to you. Understanding what their wishes are, understanding what their expectations of you are and of the other beneficiaries. Again, gaining that understanding can be very vital. It may not be that you have that opportunity, or it may be that the benefactors' parents are not in a spot where they want to kind of have those conversations, but at least try to understand what's going on there. And understand that, if there is an incapacity, we're going to be moving on the control and management of the estate. It's no longer going to be in the control of say the grantor, the parents. It's going to be moving on to someone else, likely one of the children or a sibling, for example. But it would be under a power of attorney, so healthcare power, under a general durable power of attorney, or under a trust during incapacity, and then at death, the role under a will, a personal representative, or a trustee. So they're going to be taking on that responsibility. Understanding what those rules are, how they work, what their scope is going to be key, really, for that. And then really what we're trying to do is just remind the beneficiaries here that things take time, and to keep an open mind. Hopefully, all of the parties, including all the other beneficiaries, all the fiduciaries, understand and share the same goal of following the decedent's wishes. So the documents, the will, the trust are really expressing the wishes of the decedent, and that's the job of the fiduciaries, of the trustee or the personal representative, is to follow those instructions. And then for the beneficiary's perspective, it's important to understand that does carry weight, and that they need to be on the same side there, really, to see the wishes of the decedent being followed. One more thing on that one, last one, Taylor. So also, it is the idea to be patient here. So for example, Probate, notice to creditors, and taxes all have mandatory timelines. So these things don't happen all at once. It can take months up to a year. So, okay. Fine, next one. Okay. All right, so the idea here is the beneficiary and trustee relationship. So let's say that you're the beneficiary, and now you have a relationship you found that a trust has been created for you. And what's going on with that relationship between these two parties now, the trustee and the beneficiary? We really are encouraging them to build a partnership, to have realistic expectations, transparency and communication, and really assisting with understanding and learning what the financial needs are. So when we think about the beneficiary specifically, we would recommend that the beneficiary review and understand the trust agreements, look at the language of that trust, be realistic about their needs, what they're needing from the trust, and also what their requests would be. So don't make requests that are not really something that's able to be done by the beneficiary or by the trustee. Taylor, that's the next slide, if you don't mind. So they should approach those interactions with their trustee as a partnership, not as that they're on opposite sides here. They really should be working together, find ways to find common ground there. The beneficiary is looking out for all of the the trustee is looking out for all of the beneficiaries. The remainder beneficiaries, they're trying to be compliant with the trust provisions, and they're also looking to follow their fiduciary responsibilities that are in the code, in the tax code, and the tax code, and also the state law, and within the trust document or will document. Okay.
Following up on that, at a minimum level, if you know you're going to be a beneficiary of someone's estate, it's a good idea to find out who the fiduciaries are as well. Is there a trustee? Is there going to be a personal representative? Who is that person that you'll be working with? Or is it you? It might be a good idea to know where the documents are, or get a copy of those documents so you know your rights as a beneficiary. As well as knowing if you have been designated beneficiary of any non-probate asset. It is the responsibility of the person designated on the asset to contact the bank or the custodian of that account to claim their portion of it. So you should know if you're a beneficiary there.
All right, Anita, thank you so much for being here with me today and helping take part of this. I hope that everyone has enjoyed this presentation on the role of the beneficiary in estate planning, and do look out for our next ones that are coming up. We're going to be doing 2 more here this year. In August, we have about probates and administrations, and so that's keying in really on what happens there right at the time of death. And then finally in November, we're going to talk about those fiduciaries. We mentioned those today, but we're going to dig a bit deeper into that role and understand not just the trustee role, but also the healthcare role, the personal representative role, basically all those different jobs that we've talked about all the time. How do they all work, and what happens with those? So that's what's coming up in November. And until then, have a good summer, everyone, and thank you so much for joining our webinar today.
Thanks.